receiving a nomination. Meanwhile, Parliament was again bound to hear the nominee. This was the argument we made, and it was not to attack the issue before the court. It was the action of your office, and that is why we raised it. So, Leonard Attorney General.
Minority Leader,
yes, Mr. Speaker.
We have heard you.
Very well.
Heard you.
Very well.
Please, I was compelled to give him time because you referred to it. And it's not a matter, as I directed earlier on, that is of concern to the motion that is before the House. So kindly move away from there and then make your submissions. I've taken note of the interjections, and you have enough time to make your submission. Please, you may go on.
Mr. Speaker, thank you very much. There is a point of correction, and because we are a House of record, Mr. Speaker, I think it is very, very important. The Honorable Minority Leader himself knows very well that the rules of court, CI 16, supplemented by CI 47, the High Court Civil Procedure Rules, accords lawyers the opportunity to apply for extension to file their processes out of time. This is not something strange, and there is nothing sinister in what we have done. So, Mr. Speaker, in rounding up, I wish to employ all of you, my colleagues in this House, that we approve the President's nominee because he is ably and eminently qualified in terms of Article 128, Clause 4 of the Constitution. He is one of the most experienced justices of the Supreme Court that we have, and his experience is definitely needed at this point in time in our history in order to
Honorable Minister, you are timed out. Yes, may we go to the next speaker now, and that is Honorable Tampuli Hassan. You have 7 minutes. Honorable Member, please. I was trying to get the second Deputy Speaker. I just recollected he's on an assignment. So may you kindly give me just 5 minutes. I'll be back, and then you make your submission. Sitting is suspended for 5 minutes.
Mr. Speaker,
Honorable members, next, let's now listen to our colleague, Honorable Tampuli Hassan. You have 7 minutes.
Thank you very much, Mr. Speaker, for giving me the opportunity to contribute to the report before this House. Mr. Speaker, in doing so, I would like to seek your guidance on paragraph 6.18 on page 27 of the report. And Mr. Speaker, based on your ruling and your interventions in the course of the reflections that have been shared by prior speakers, I would like to seek your guidance, Mr. Speaker. The committee says, for instance, and I quote, "The committee raised concerns regarding the propriety of proceedings with the vetting process, given the pending legal suits challenging the removal of the former Chief Justice. In regard to the fact that you have made your ruling, is it out of order if one continues to speak to this same report in accordance with the rules of this House?" Mr. Speaker, I'd like to seek your guidance.
Honorable member, I made a ruling earlier on this matter, not today. In fact, it was a written ruling I delivered here on this matter. And I say none of you challenge that ruling. And that ruling remains the ruling of Mr. Speaker and is binding on the House. So we can no longer go back to it. I was talking about my act, not the act of the nominee. Please, and I stay by that.
Thank you, Mr. Speaker. I'll be guided accordingly. Mr. Speaker, it has to be put on record that Justice Paul Bafo-Boni, the nominee for the office of Chief Justice, was appointed to the Court of Appeal by His Excellency President John Agyekum Kufuor. Mr. Speaker, at the time that he was being nominated or appointed to the Court of Appeal, there were High Court justices who had served in the High Court long before him, but President Kufuor found him suitable to be taken to the Court of Appeal. Mr. Speaker, subsequently, after 2 years, even though Justice Paul Bafo-Boni met his seniors at the Court of Appeal, President Kufuor again found him suitable to take him to the Supreme Court. So, Mr. Speaker, largely we on this side of the divide are not opposed to the nomination of Justice Paul Bafo-Boni for any personal. Listen to me, Mr. Speaker. Mr. Speaker, we are not opposed for any personal reasons. We are opposed to his nomination based on principle of the pendency of matters by the Justice Takonu, which are still pending before courts. And we have taken this principal position just to let you know that we do not have any issues. In fact, we don't just want to join issues with you especially regarding the matter of Justice Paul Bafo-Boni. Mr. Speaker, we have to look at this matter within the framework of the preamble of the 1992 Constitution. Mr. Speaker, we the people of Ghana, in the exercise of our natural and inalienable rights to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity. Mr. Speaker, it continues, in a spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitments to freedom, justice, and probity and accountability. The principle that all powers of government spring from the sovereign will of the people, the principle of universal adult suffrage, and, Mr. Speaker, my emphasis, the rule of law, supremacy of the Constitution, equality before the law, and respect for the fundamental human rights and freedom of our people. Mr. Speaker, in terms of fundamental human rights of the people and access to justice, Mr. Speaker, embedded in that rule of law thing is the accessible and impartial justice. Mr. Speaker, we must be given usable opportunities when we think our rights have been violated to be able to vindicate our rights. Mr. Speaker, one of the things that we must advert our minds to is that when there are pending matters, it's important that I am allowed to finish the process before a decision will be taken that will prejudice my rights. And Mr. Speaker, we are not saying this because this is Justice Tokono, but this right must be available to every one of us and every Ghanaian. Mr. Speaker, fair legal procedures. Mr. Speaker, if I take a matter to court, I have every right to complete the matter before I'm told that my issue is foreclosed. Mr. Speaker, if matters are pending before courts and you leave the office, Mr. Speaker, Article 1446 provides situations where a justice of the Superior Court, including the Chief Justice, may lose office. Stated misbehavior, incompetence, and inability to perform the functions of the office. Mr. Speaker, what we are saying is that if we go ahead to confirm Justice Paul Bafo-Boni and he becomes the Chief Justice, and in the event that the pending cases terminate in her favor, what happens to that office? Mr. Speaker, we anticipate that there will be constitutional nuclear meltdown, and that is what we intend to avoid.
Honorable member.
Mr. Speaker.
Honorable member, please. I don't know how many times I have to draw the attention of members to this matter. That is not what is before us. Finality of the rule of law is pronounced and is in the bosom of the courts. Legislative power, the power to make laws, is in our bosom. The Constitution added the power to approve, that is, give prior approval to nominees by His Excellency the President. And that is exactly what we are doing. As to whether our decision is the final rule of law, is for another body to determine. And so the proper venue, and I keep on emphasizing that, is not this House, it's the court. And so please, once you have the matters pending there, the matters will continue to pen there, and you can vindicate those rights there. The judiciary cannot say that because Parliament is considering a bill that may have some effect on a matter before the judiciary, they'll have to hold on until we pass the bill before they proceed with the matter. They can't say that. the same, I'm just putting it in simple language, that once a matter is before the judiciary, they can't say because that matter is before the judiciary, Parliament is stopped from also performing its function of lawmaking, of oversight, of these approvals and the rest until they finish adjudicating the matter. So we have to go on with ours. And that is exactly what we are doing. We cannot be stopped. I have given my ruling on this, and you are bound by it. If you are not, you know the rule in our standing orders. You know what to do. If you are not satisfied with that, you also have the courts to go and vindicate your rights. But so far as the matter before us is concerned, let's stick to that matter. Let's go on with that, and then later on you can proceed with whatever you want to do. But for me as Speaker, I preside. I don't judge. I preside. And I'll preside and make sure that what the rules say should happen will happen. At the end of the day, the House will be given the opportunity to take the decision. The rest, you can proceed on after that, please. So let's move on to the matter before us.
Thank you, Mr. Speaker. Mr. Speaker, I'm guided. Mr. Speaker, next I would like to refer this House to Article 1254 of the Constitution, where it says that the Chief Justice shall be subject to the Constitution as be the head of the judiciary and shall be responsible for the administration and supervision of the judiciary.
I told you about the timing. When there was the interjection, it stopped. It's automatic. It's not being controlled by me. Please, kindly give him 1 minute. 1 minute.
Thank you, Mr. Speaker. Mr. Speaker, what that provision provides for is that we are not looking at the Chief Justice's capacity as a Justice of the Supreme Court, but as the head of the judiciary in terms of the human resource, planning, organizing, directing, control, and discipline of the judicial human resource, the judicial service staff, including even judges. Mr. Speaker, one would be not too far away if you ask the acting Chief Justice whether or not he will be transferring judges, whether or not if a justice of the Superior Court, conducts himself or in any way he will be taking action against the person, or whether or not any disciplinary action can be taken anybody as a judge or any staff of the judicial service. Mr. Speaker.
The 1 minute is over again. So, but honorable member, don't be worried about that, because even this constitution, when it was being drafted, it was said to be drafted by hairdressers. Now, when it was approved, the people who stated that the hairdressers were drafting constitution kept on applauding the good works of the hairdressers. So, and you have also done that today. It's just that politicians are a different breed of human beings. So that is the challenge we have in the world. May we proceed to the next person, and this time from the majority side, and that is Honorable Eric Opoku. Honorable, you have seven minutes.
Thank you very much, Mr. Speaker, for the opportunity to contribute to the motion before this House. Mr. Speaker, this House is witnessing inconsistency in its highest apogee. Inconsistency that has never been seen on the floor of this House, except today. Mr. Speaker, you recall that in the last year of Mr. President John Agyekum Kufuor, 2008, Justice Paul Bafuboni was elevated to the position of Supreme Court Justice. And the Appointments Committee's report was submitted to this House for approval. Mr. Speaker, that day, records of this House indicate that the minority we see today, they were in the majority. And they extol the virtues of this man right in this chamber. They describe him as competent. They describe him as competent, a man who has served this nation with dignity, an honest judge. In fact, they said a lot of good things about this man. Mr. Speaker, what has changed? What has changed? Today, the same person has been elevated, and now you are opposing his nomination. History will be the best judge. Mr. Speaker, again, I heard Honorable Enyimadu spoke about executive manipulation of the judiciary. Mr. Speaker, you recall that between 2003 and 2006, Justice Paul Bafuboni was appointed to the Fast Track High Court. He was appointed to the Fast Track High Court, a court established by President Kufuor, tried some cases, and after some years, declared unconstitutional in the history of our country. That was the period of executive manipulation of the judiciary. That was the period. And it happened under your watch. And today you have the courage to sit in the same chamber and talk about executive manipulation of the judiciary. Mr. Speaker, again, you are ruling on the matter, on this matter, is fortified by this report.
Honorable member, please. May we listen to, yes.
Mr. Speaker, very respectfully, I stand on Order 122 to clarify a point. Mr. Speaker, we don't appoint to the Fast Track High Court. We appoint to the High Court. So, Mr. Speaker, that clarification would have to be clear. There's nothing like we appoint to the High Court and not the Fast Track High Court. When you are appointed to the High Court, you are then assigned to a division of the High Court. Mr. Speaker, this is the point. You don't appoint to the High Court.
Mr. Speaker, Mr. Speaker, Mr. Speaker, it is in the report, page 8. Page 8 of the report. Listen. Page 8 of the report. He was elevated to the High Court in 2000, serving at Sunyane and Kumasi between 2000 and 2003, and later appointed justice to the Fast Track High Court. You see the report? So what's your problem? So, Mr. Speaker, I was speaking to the report, exactly how it is captured in the report. Now, Mr. Speaker, you are ruling on the matter that while Parliament is discharging a lawful duty, no court action can stop that, is fortified by this report. And it's interesting we raise this issue for Ghanaians to know. Mr. Speaker, paragraph 27 of the report.
Honorable member, your leader is on his feet.
Okay.
Yes, please.
Mr. Speaker, I have been trying very hard to get members on this side to listen to opposing views. I urge our colleagues to also pay attention and listen so that we can expedite action on this matter. I'm just appealing to our colleagues on the other side.
Honorable members, please, we need to listen to each other. Honorable Doctor, he represented Parliament at our march against the judiciary. He was among the 11, and he ran all over the field without touching the ball. And he was substituted. So I understand that. Honorable members, please, we only consider and give prior approval to nominees of the President to the Supreme Court. The High Court and the Court of Appeal don't come before the House for prior approval. Please, that is the state of affairs. The process that he went through, I was minority leader. Concerns were expressed, but this was not a matter that came before the House for his approval or otherwise. Not at all. Please, let's go on.
Thank you very much, Mr. Speaker. Mr. Speaker, I was saying that reading page 27 of the report, under point 6.18, propriety of proceeding with the vetting process. Your committee has reported, and indeed they have cited two major cases, one involving a member of this House, Honorable Vincent Asamoah versus Attorney General, and the report reads, to substantiate his position, the nominee cited relevant legal precedents, including Dufour versus Bank of Ghana and Vincent Assefuah versus Attorney General, both of which affirm the principle that the existence of a legal challenge does not suspend constitutional processes in the absence of an explicit court injunction. Mr. Speaker, these two cases.
Honorable member, I ruled on that, so let's move on.
Mr. Speaker, I'm moving on because our colleagues, when I raised the issue, that the same person, when he was brought here, they extolled his virtues. They said no, they are not opposed to his nomination, but they are talking about some legalities. And the basis of their argument is that there is a case that is to stop the proceedings of this House. And I'm reading this to fortify your ruling that they don't have basis. Their argument is baseless. They are only talking because they are in the minority and they want to be heard. Otherwise, they'll have no case at all to be even making noise in this House. The truth of the fact is that the man qualifies, he is competent. In fact, he is the first son from our region, Ahafo, to be elevated to this position. And the people of our region are solidly behind him. And so we urge our colleagues on the other side that you cannot oppose everything on this earth. You were here defending some few days ago. Now you are transmoging.
Honorable members, we move on to the next person. And that is the last from the minority caucus. And the leader himself wants to take up that task. So I call on Osahene Afenyo-Markin.
Mr. Speaker, thank you for the opportunity to add my voice to this debate on the floor. Mr. Speaker, in making my contribution, I would want to, in addition to the report, rely on the certified copy of the verbatim report of proceedings that has been served on my good self by the clerk through the chairman. And for the avoidance of doubt, I would want to make same available to the table office for the record, because I'm going to rely on same. Mr. Speaker, that said, I shall proceed to say that for the first time under the 1992 Constitution, a sitting Chief Justice has been removed pursuant to Article 146 of the Constitution. Mr. Speaker, that removal, effected on 1st September 2025, following recommendation by a committee chaired by His Lordship Justice Gabriel Puaman, has generated unprecedented litigation challenging its constitutional validity, procedural regularity, and legal effectiveness. Critically, several proceedings were filed before Her Ladyship's removal was finalized. These are contemporaneous constitutional challenges asserting fundamental and irredeemable flaws in the Article 146 process. The removal proceeded despite these pending objections. These objections now remain unresolved before multiple courts of competent jurisdiction. Mr. Speaker, we, the minority, hold the view that there has been inconsistency in the approach in this matter, and that if care is not taken, this country that we all seek investment for may not attract that needed investment. Mr. Speaker, as we speak, the prima facie findings of the Council of State remain unpublished. 2, as we speak, the very report that recommended...
Honorable Member, I thought your reference to this matter was a matter before the House.
Yes, Mr. Speaker.
But what you are talking about is not before the House.
Mr. Speaker, then let me use the phrase well. Let me rephrase it for the purpose of clarity. Mr. Speaker, my submission is to the effect that the matters giving rise for this motion to be taken are such that we, the minority, still believe that there are serious matters for the Constitution of our Republic. Mr. Speaker, and I say so because today we consider this nomination, and you have made it clear that our approval or otherwise does not bring a finality within the context of the rule of law, which I agree. I'm not contesting that. But it is our view, most respectfully, that one, the fact that the prima facie determination is not in the public space is of concern to us. 2, the fact that the recommendation, the report that gave rise for the final decision of His Excellency the President is also not in the public domain is of concern to us. Mr. Speaker, we contend that for the purposes of transparent democracy, the era where the citizens require information it should have been an instinctive, inherent decision to have released a report. Because, Mr. Speaker, we hold a view that this was no less a matter because it was dealing with an organ of government, of state, the judiciary. That is our contention. Mr. Speaker.
Honorable Member, as I said, you are complaining about acts of another arm of government.
Mr. Speaker, I hope my time is being stopped.
Not Parliament. Not Parliament.
No.
And those matters are not before Parliament. And so I have consistently guided you and your colleagues to deal with the matter before Parliament. Continue with the others at the proper forum, not the floor of Parliament.
Mr. Speaker, we are not litigating those matters in Parliament, but those matters gave rise to this, what is before us. So what I'm trying to do is to give a background to the very matter before us, Mr. Speaker. Mr. Speaker, the Honorable Eric Opoku in his submission argues with some force that executive manipulation started in Kufuor era. I found it very rich. And he tries to use that to justify the concerns that we are raising to say that we are acting in double standard. No. Mr. Speaker, in President Kufuor's era, no Chief Justice was removed. Mr. Speaker,
Honorable member,
Mr. Speaker,
please. I don't want us to go beyond what is before us, because many of the things that you say, because many of you were not born early, you don't know, you don't have the information. And in fact, I have bought some books, and I'm going to distribute the books particularly to leaders, so that you read to see the perception that we have given to the people outside there. They are very senior, intelligent people who held high office of state, who have written some books about Ghana politics. I have the books. I bought plenty copies to distribute to you free to read. I believe that will change your approach to how you go about the business on this floor. The information that I have from experience in this house, if I disclose them, many of the things you say are incorrect. The presidents and former presidents, they know. You don't know. And they know that I know what I'm talking about. So please, confine yourselves to the matters before the House. Let's deal with that one.
Mr. Speaker, we are saying that the fact that there appears to be some right violation against Justice Araba Isaba Tokunu, we in the minority are unable to support this nomination. Mr. Speaker, the learned Attorney General, in his submission, alluded to the fact that even when Parliament approves this nomination and the court determines otherwise, the executive would be bound to respect it. He was right in saying that when a court makes a pronouncement, the executive will be bound by it. But what he did not say is the conduct of his office in the handling of the very matter that he is saying when there is pronouncement, they would be bound by it. Mr. Speaker, he himself submitted that the rules of court allows for extension of time application to be made. The question we ask is that why didn't the Attorney General, considering the enormity of this matter, act with alacrity? Mr. Speaker, the question that begs for an answer is that for all these periods, if justice was really meant to be done, why didn't the Attorney General file a defense? He is now saying that we shouldn't worry, and that if there is any positive outcome, the president will be bound by it. But we are interested in the process. The minority in this House is interested in the process, and it is contending that his actions amount to bad faith and denying the respected
Honorable Minority Leader. Honorable Minority Leader.
Yes, Mr. Speaker.
I acknowledge that the minority is interested, and you are expressing your concerns. And those concerns have also been expressed at the right forum. But I say this is not the forum for that. The Attorney General's conduct of conducting proceedings in that court is not before the House. That at all is not. And so please, let's handle what is before us. Then at the appropriate forum, which you are doing, you continue with it. You can just refer that this is what you are doing, but don't go into the details.
Speaker, with respect, Mr. Speaker, just place my time on ice for us to interrogate this preliminary matter. Mr. Speaker, well, I will leave it to you, but I would want to learn. Mr. Speaker, in my submission, I was responding to the Attorney General. These are facts that he has made known to the House. So I was responding to his own argument. I was not saying anything new. It is what he said that I was referring to. But if you say I shouldn't delve deep into it.
I stopped him.
Mr. Speaker, very well.
I stopped him.
Very well.
And I said he should come back to the subject matter on the floor.
Very well. Mr. Speaker, that's
please.
All. Mr. Speaker, if it is so, I will not belabor. Mr. Speaker, today, our colleagues who vehemently opposed just 2 nominations to the Supreme Court, and when they had the opportunity, they brought 7. Their principled argument vanished into thin air. Today, Mr. Speaker, when our friends in the NDC argued against 2 nominations to the Supreme Court, when they had the opportunity, they brought 7 at a go. Today, the same people who opposed this nominee in 2008 are today saying that they are for his cause. Mr. Speaker, we leave everything to posterity. Every single thing that we are witnessing in this House is for posterity. But we believe as minority that in spite of all that is happening, which happenings is affecting the rights of a citizen, the best days of our country are ahead of us. Mr. Speaker, we would not belabor. we maintain our opposition to this nomination and we reject same, and we are going to demand a secret ballot to reject this. We are going to demand a secret ballot to vote to let Hansard record our opposition. Mr. Speaker, we know that there are members who have their own views and would want to exercise their right when there is secret ballot. We, the minority, are going to invoke that so that we take a secret ballot to register our dissent on this matter. Mr. Speaker, I wouldn't exhaust the 15 minutes. I will submit here to and then leave the matters to rest. Thank you so much.
Honorable members, the last person to have a say on this matter is the majority leader. The minority leader actually used less than 15 minutes. So it's the majority leader who is now to end the debate, and he has 15 minutes to do so.
Mr. Speaker, mine is a very brief one. Very brief. In 2012, we had a national election for the presidency and for parliament. The election results were disputed. President Akufo-Addo was declared winner. John Dramani Mahama and the NDC petitioned President John Dramani Mahama was declared winner. Akufo-Addo petitioned the courts. Mr. Speaker, in 2020, we had another election, and President Akufo-Addo was declared winner, and John Dramani Mahama petitioned. The cases traveled before the Supreme Court, and finally, the Supreme Court made a pronouncement. Mr. Speaker, it was clear to every Ghanaian that in spite of the cases pending in the Supreme Court, we went ahead and swore in those declared by the Electoral Commission as having been validly elected. But the case went on, and in the case of the petition against John Dramani Mahama, it was in August 2013 that the Supreme Court handed a ruling. Mr. Speaker, when we put the question to the nominee as to what he thinks will happen if the previous Chief Justice's case turned out in her favor, he simply referred us to these two cases. If in a presidential petition, we are convinced that if the ruling goes against a sitting president, that person will vacate the seat so that the winner will take over. Why would we entertain doubt that if a Chief Justice who has left office gets a ruling in her favor, that the sitting Chief Justice will not give way so that the decision of the Supreme Court will be enforced? So the answer is simple. We have to proceed. And when
the decisions of the courts come. And the implications are that what has happened should be reversed. The Chief Justice nominee said he is ready to give way, and whoever the courts declare in favor of will come and occupy the post of Chief Justice. So there's no problem. Mr. Speaker, the second issue about the listing of cases was put to the nominee, and the nominee explained that he, as acting Chief Justice, is not responsible for listing cases. So if the minority's position was that some cases hadn't been listed, then that is a matter for the registry, because as an acting Chief Justice, the Chief Justice normally empanels the court when the registrar indicates that all the processes had been concluded, and then we had reached a stage where we would need to empanel a court. So he wasn't responsible for cases not listed. Mr. Speaker, I think that a lot has been said already about the nominee, and I will not belabor the point, except to once again, lastly, register the point that in 2012, July 24th, 2012, Justice Theodora Wood was nominated, approved by this House, and appointed a Chief Justice. 2013, January, President John Evans Atta Mills, under the NDC, became president. He coexisted amicably with Justice Theodora Wood, who was appointed by President Kufuor under the NPP. Mr. Speaker, again, on 24th of July, 2012, when we lost the president, John Dramani Mahama took over as the president, and he coexisted amicably with Justice Theodora Wood, who was appointed by President Kufuor, an NPP president. What is my point? My point is simple, that the NDC under President Atta Mills and under the current president, John Dramani Mahama, has coexisted peacefully with a Chief Justice appointed by the NPP. So, Mr. Speaker, let me conclude by saying that my colleagues have already argued and given reasons why we should approve the nomination to the post of Chief Justice, because essentially he qualifies under Article 1284 of the Constitution, has been a judge for 30 years, overly qualified, has been a Supreme Court judge for more than a decade and a half, and is now acting as the Chief Justice. Mr. Speaker, without saying more, I will just say that put the question and we will vote. Thank you, Mr. Speaker.
Honorable members, honorable members, at the conclusion of the debate, I put the question. Those in favor of the adoption of the committee's report, say aye. Those against, say no. Honorable members, I put the question again. Those in favor of the adoption of the report of the committee, say aye. Those against, say no. Honorable members, I think the ayes have it. Honorable members, we have the Honorable Deputy Whip, Minority Deputy Whip on his feet. Let's listen to him.
Thank you, Mr. Speaker. Mr. Speaker, I rise under Order 1513. Mr. Speaker, Order 151. Mr. Speaker, I rise under Order 1513. Mr. Speaker, with your leave, I read Order 1513. A member may challenge the decision of the Speaker on a voice vote, and the Speaker shall determine whether to call for a head count or electronic vote. Mr. Speaker, I invite you for us to do a head count on this since our electronic vote is not working. Speaker, head count.
Honorable members, there's a challenge to my decision on the voice vote, and there's a call for us to take a head count. Yes, Majority Leader.
Mr. Speaker, let me read Order 1513. Well, it says, a member may challenge the decision of the Speaker on the voice vote, and the Speaker shall determine whether to call for head count or electronic vote. Whether. Mr. Speaker.
Keep quiet.
Whether. Mr. Speaker. There is no automatic right to a head count or electronic vote when somebody challenges the voice vote. There's no automatic right. It is for the Speaker to look at the chamber. Because where Mr. Speaker sits, he sees the numbers. Where Mr. Speaker sits, he sees the numbers. He sees the number constituting the NPP votes, and sees the number constituting the NDC votes. And Mr. Speaker knows that the NPP micro-minority have already indicated they are voting against. The NDC supermajority has already indicated they are voting for. So when you look at the numbers in the chamber, it is so clear that it becomes unnecessary for a head count. Mr. Speaker,
So, Mr. Speaker, we have confidence in you and your understanding of the rules. The rules say that a member may challenge the decision of the Speaker on a voice vote, and the Speaker shall determine whether to call for head count or electronic vote, or whether not to call for head count or electronic vote. Mr. Speaker, it is obvious, and there's no need for you to call for a head count or an electronic vote. It is obvious that they have lost the vote. We've won the vote, and take a decision and let's proceed. Thank you, Mr. Speaker.
Honorable members, I have determined that there should be a head count. So we are going to do a head count. Head count. Please.
Thank you, Mr. Speaker. Mr. Speaker.
Honorable members.
Mr. Speaker.
We are going to do a head count.
Mr. Speaker.
Please, those in favor of the motion, please rise up to be counted.
Mr. Speaker. Mr. Speaker, there is a problem. There is a problem, Mr. Speaker. Mr. Speaker. Mr. Speaker. Mr. Speaker, I want to draw your attention. Mr. Speaker. Mr. Speaker, I want to draw your attention to the Constitution in Article 111. Mr. Speaker. Mr. Speaker. Mr. Speaker, the Constitution in Article 111.
Bahama bako nimba bebre.
Why is it challenge? Please, honorable members, be at your seats. Members are moving around and they are having a challenge in counting you. Please, say rise up, rise up. Please. Honorable members, you may resume your seats. Resume your seats. Honorable members, those against the motion rise to be counted. Please, clerks at the table, you are asked to count all those who have risen. Please, so any person that has risen and is standing should be counted. Honorable members, you may now resume your seats. Resume your seats. Honorable members, at the count, the ayes have 163. The noes 69. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, I rise under Order 1526. Mr. Speaker, I rise under Order 1526. Mr. Speaker, for the avoidance of doubt, I read. Order 1526 states that where a member rises to challenge the results of the head count, the Speaker shall call for division. So, Mr. Speaker, I therefore challenge the head count, and I call for you to apply Order 1526 as stated in our orders for division, Mr. Speaker.
Honorable member. Majority Leader.
Mr. Speaker, Mr. Speaker, the member rose and quoted Order 1526. And I just heard him read, where a member rises to challenge the results of the head count, the Speaker shall call for a division. I have not heard him challenge I did not hear him challenge the head count. I did not hear. I did not hear him challenge. I did not hear him challenge. You did. He told him. I did not hear him challenge. I did not hear him challenge the result of the head count. So, Mr. Speaker, let him come properly. I did not hear him. But Mr. Speaker can give a ruling if you heard him challenge the the results of the head count. I did not hear him.
Yes.
Thank you very much, Right Honourable Speaker. Mr. Speaker, I rise to plead with you and draw your attention to Order 154, which states, and I read, despite Order 153, the Speaker may, if in the opinion of the Speaker, a division has been unnecessarily claimed, take the vote of the House by calling upon the members who support or who oppose the decision of the Speaker to rise and be counted, upon which the Speaker shall declare the decision of the House or direct that a division be held. Unquote. Mr. Speaker, in drawing your attention to this order, I plead that you exercise your authority as expected in that standing order, given that the numbers after the count speak for themselves, and the call for a division is an unnecessary request. Mr. Speaker, I thank
you. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, when I rose earlier on, Mr. Speaker, Mr. Speaker, Speaker.
Yes.
Mr. Speaker.
Yes, go on.
Mr. Speaker, when I rose earlier on, it was under Order 1526. And that I challenge, and it reads that where a member rises to challenge the results of the head count, the Speaker shall call for a division. Mr. Speaker, therefore, I challenge the results from the head count and call for a division under Order 1526. Mr. Speaker, even though the Honourable Member for Tamale North, Honourable Soyini, drawing your attention to Order 154. Mr. Speaker, Order 154 is clear that despite Order 153, I haven't raised anything under Order 153. I am within Standing Order 1526, which is mandatory to the Speaker. Mr. Speaker, I make my case. Thank you.
Honourable Member, I'm still waiting to hear your challenge.
Mr. Speaker,
it's not sufficient to say a challenge.
Mr. Speaker, Mr. Speaker, to make my earlier on, I tried to draw your attention. Mr. Speaker, I made this challenge because number one, Mr. Speaker, I did not believe that the number as presented to you from those who voted for the yes or the ayes were up to the number presented to you, Mr. Speaker. And also, I was drawing your attention to Article 111 of the 1992 Constitution. And Mr. Speaker, I read Article 111. The Vice President or a minister or a deputy minister who is not a member of Parliament shall be entitled to participate in the proceedings of Parliament and shall not be accorded the privilege of all members of Parliament except entitlement to vote. Mr. Speaker, the time we were taking the vote, the Ashanti Regional Minister is seated there. He's still here. Mr. Speaker, the Works and Housing Minister is still seated here. He has no right to vote. That's my basis for my challenge, Mr. Speaker.
Yes, Majority Leader.
Mr. Speaker, Mr. Speaker, Mr. Speaker, Order 153 and Order 152 and Order 154 must all be read together. Because Order 154 says that despite Order 153, the Speaker, if in the opinion of the Speaker, the Speaker may, if in the opinion of the Speaker, a division has been unnecessarily claimed, a decision has been unnecessarily claimed, take the vote of the House by calling upon the members who support or who oppose the decision of the Speaker to rise and be counted, upon which the Speaker shall declare the decision of the House or direct that a division be held. Mr. Speaker, if you read Order 153, it deals with division and says the Speaker shall direct that the lobbies be cleared in the case of a division. The division bell shall be rung for 1 minute. The Speaker shall invite the leadership of the majority, minority, or independent caucuses to appoint 2 tellers each to observe the division process. After a lapse of 5 minutes, the Speaker shall announce the names of division clerks and the tellers. So 153 deals with the procedure for division. Is that okay? And 154 says that in spite of the fact that there is a procedure for division, Speaker can also say that a division has been unnecessarily claimed. That's 154. And if the Speaker takes a position that a division has been unnecessarily claimed, the procedure is that he would ask one side only to rise up and be counted. Just one side. He can say that because you are not many and you are just 69, it is easier to count you. So you rise up and then he will count you. When he counts you, he can direct and declare the decision of the House. That is what 154 says. That's what 154 says. So I therefore call on Mr. Speaker. I therefore call on Mr. Speaker to rule that a division has been unnecessarily claimed. And on the basis of a ruling that a division has been unnecessarily claimed, to proceed to count one side and then declare the decision of the House. Thank you, Mr. Speaker.
Honourable members, Minority Leader, yes.
Yes, I think I mentioned it to you before.
Speaker, with respect, the Honourable Member for Tolon invoked Order 152 and was very clear in his application. The Order 153 that provides for procedure on division anticipates that possibly there 151 that was initially invoked, which gives rise for a head count, could be wrong. It is a reason why there's a whole procedure provided for under 153, which talks about clearing the lobbies, which talks about the leaders providing tellers. Mr. Speaker, in the first instance, it is the clerks who have done the accounting, not independently verified by anybody, and they have brought the figures to you. The member has challenged it, and that is why the second stage step allows for agents, that those who are saying no, those who are saying yes, will have an opportunity to validate the counting process. Mr. Speaker, for the majority leader to immediately invoke 154, to say that 154 says, despite 153, Speaker may. Mr. Speaker, that provision there must not be construed in a manner to negate the mandatory obligation under 1526. No, it is saying where the number, if you read 153, 11 and 12, it says that if a member states that he voted in error and that his vote was counted wrongly, the member may request that the vote be corrected or counted before the speaker declares the result. 11, where the member numbers in a division are equal, the motion shall be considered lost. Now, Mr. Speaker, if you read these together, it is rather dealing with a situation where a declaration is made under 153, and the speaker would want to exercise a discretion where a member is unnecessarily making a claim under division, because it anticipates that a member may not be satisfied and may be taking certain steps to make a certain application. If they now move away to refer to 152, Mr. Speaker, that is not in the contemplation of this regulation. If the intendment of Parliament was to the effect that Mr. Speaker can invoke 154 to, as it were, negate the effect of 1526, Mr. Speaker, the Parliament would have said so. It did not say that despite Order 1526, Mr. Speaker, in his opinion, may consider a division unnecessary claim. No, 154 does not make reference at all to 1526. Mr. Speaker, that provision does not make reference to it at all. If the lawmakers had intended the 154 to have effect on 1526, it would have said so in clear language. Mr. Speaker, what has not been written or said is not meant to be added to the whole lot for interpretation. What 154 contemplates is the 153. That is why it mentions 153 without more. Nobody should attempt to lead Mr. Speaker astray. There is a huge temptation. There's a huge temptation. Earlier, the majority leader said Honorable Habib did not challenge. So he didn't hear. Now he moves away. He moves away to now invoke 154. The 154 is contemplating 153. Mr. Speaker, I would not want us to further delay this. 1526 is mandatory, and I'll conclude on it. It says where a member rises to challenge the results of the head count, the speaker shall call for a division. I don't know why the super majority is afraid. What are you afraid of? What are you afraid of? If you have your numbers and you believe in your numbers, let's go into division. If you believe in your numbers, let's go into division.
Honorable Minority Leader. Honorable Minority Leader, you have made your point. The Honorable Habib mentioned a particular member. I just want to know whether the member was present when the head count was being taken. Please, I want to know from the member, please. It's not from any of you. Is a member present? Please, I want to hear from the member. Yes, honorable member.
No, come here. Come and use this one. Come and use this one.
Honorable member, yes.
Okay, you come and use it. Let's do it. Man, so who there? So just speak straight.
Mr. Speaker, respectfully, during the head count, myself and the Honorable Minister for Works and Housing, we were both outside the chamber. We were not counted during the head count. Thank you very much.
You walk them out. What of this what was it?
Yes, honorable members. Honorable members, it's my view that the division has been unnecessarily honorable member. Honorable members, the division has been unnecessarily claimed. Honorable members, please resume your seats. Honorable members, the motion has accordingly been adopted. This Honorable House has accordingly approved the nomination of Justice Paul Bafubone as Chief Justice of the Republic in accordance with Article 114, Clause 1 of the 1992 Constitution, respectively. I want to take this opportunity to, on behalf of the House, congratulate the nominee on his approval by Parliament. Yes. I urge the nominee to take all what has happened right up from the day of the nomination up to his approval, I should say prior approval by Parliament, into consideration in his tenure of office. Once again, congratulations. Yes, please, First Deputy Speaker.
Right Honorable Speaker, thank you very much for giving me the opportunity. I rise to thank the committee sincerely, particularly those who were present and vetted the nominee. I also want to thank the House, particularly those who were on their feet to be counted in favor of the adoption of the report of the committee. Thank you very much. God richly bless you.
Honorable members, honorable members, honorable members, please, I have a statement. It is actually what we call corrigentum. On 10th November 2025, I had the pleasure and honor of receiving a delegation from the Queen Mother's Foundation, led by their president, the Queen Mother of Kayira in the Ofinsu traditional area, Nana Amma Sewa Bonsu. Their well-intentioned visit afforded us the opportunity of discussing some proposed constitutional amendments, ways of empowering chiefs and queen mothers to protect the environment, stop illegal mining, and facilitate development. However, in communicating their visit to Parliament, I inadvertently referred to Nana Amma Sewa Bonsu as the president of the Queen Mothers Association and Queen Mother of Ofinsu. I wish to apologize to the Ofinsu Traditional Council and the Queen Mothers Association of Ghana for the regrettable error. Let me reiterate that Nana Amma Sewa Bonsu is the president of the Queen Mothers Foundation and not president of the Queen Mothers Association. She is also the Queen Mother of Kayira and not Queen Mother of Ofinsu. As a chief myself, I appreciate and respect traditional protocols and will be the last person to disregard the authority vested in our chiefs and queen mothers. I always welcome every opportunity to meet traditional authorities to discuss ways of exalting their roles in governance and in making them the fulcrum of development in the country, particularly in their jurisdictions. With all humility, I say, Kafra, Kuse, to our revered kings and chiefs, queens and queen mothers of the Ofinsu traditional area. I thank you for your listenership. Honorable members, we will take one item and then take a short suspension before we come to the main item of today. On the order paper, we have this bill that we have been working on for some time now, and it is as item 13 on the order paper, the Ghana Scholarships Authority Bill 2025 is now got to the third reading. I have not received any request for us to be taken to a second consideration stage. So I want us to take it now before we go on the suspension. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, just to remind you that we had agreed that motion 15 on page 4 of today's order paper be taken. Mr. Speaker, I understand that.
Yes.
Mr. Speaker, if you could permit me to move the motion now before the minister responsible for education will do the scholarship authority bill. Mr. Speaker, I'll be very snappy on my motion. It has been there for very long.
Please, I'll have to then suspend for 5 minutes. The House is sitting is accordingly suspended for 5 minutes.
My people for just 2 minutes.
Yo.